Bismillahirrahmanirrahim. Humanity and Gender Committee ke tawrge hatalis sunabadalbu Kuriya Medani. Sexual violence in South Asia, legal and other barriers to justice for survivors. Dirasa gulabata mashwara kurmataka equality now ade utama jamiyai befruna badal kurmataka. Engi wadana wan fada miwagutu me committee ga oi bill takuge thering madkola cheki miwagutu me committee government dirasa kuramunda hamaikani mi bilaki mi jinsi kushuge kanun han islahu genamge bill nalwe kura dirasaya mi dirasaya ki wara muhimmu dirasaya ei rajyege ganunta mi jinsi kushuge ganunta huri gota ega huri geptaka ega huri masoltaka henkamu islahu kuramvi kankam fahak koddeva oi report ki mi gori kankama gole gotun masdiha mashwara kuruman edumun alundu men committee mi bani nimmafa mi wara muhimmu kame gotoka mi waku talumen dirasa kuramunda committee hema mi fursat ge beenu committee hifan nimmi nehme goto mi edoge baddal gumuka utamage farat humet abdul gafur mariam muhammad didi adi ane mi equality now a mi dirasa ga baveri vadane mi dirasa mi consultant adi mi liuvi farato getering me e farakama vadi via Srinivasan online ko almena barada ganane maludu mi wagutu kuriya befurunge is no enama mi vadante befurna dawataru anade befur wadatuma fahu mi online ko barada nawa fara committee join kuruma fursate almarwan Furtam Kamaka Human Rights and Gender Committee Hatavis on about a sexual violence in South Asia, illegal and other barriers to justice for survivors. Me dirasa golego to mashwara kuruma me committee badal kuraba committee utama kafarato vadanti be umeda abdul gafur shamari muhammad diya committee ge faratana aduganiga medana bushukuru danawa mi badagumuga mi Divya Srinivasan equality nauge faratum mes baradanawa alugandu fahakolam benu me mivagutu me committee indirasa kuramunda hamaikani bill di muhim bill gutu community jinsi kushuke gaanuna islah kurumuge bill ehen kamun mi baddagumaki mi committee wara muhimmu baddagumen ei mi dirasa ke zariyain mivagutu gaanunta ugahuri gaps identify kurumalu and memikura monda dirasa varabodu hivare varabodu bare libigende ehembe mami badavun vadan devi comment ka adisa farshu kurdan nalmenda me muhimmu kan alugandu takura koldam beenuve I would like to extend a very warm welcome to Ms. Divya Srinivasan on behalf of the committee and myself, and would like to thank you for joining this very important meeting today, because the bill in focus in the committee right now is the bill on amendments to the law on sexual violence, and therefore this research and its outcomes and its findings, especially that on chapter on the protection gaps in laws relating to sexual violence, page 17. I don't know if you want, I can share. Me chapter, the chapter on protection gaps in laws relating to sexual violence is of utmost importance and relevance to us at this moment, because we are currently reviewing the law on sexual violence. And so the gaps and issues identified and what we need to amend in terms of this research, and also in relation to international commitment standards, is very important for us to know. And so I would like to open the floor to the participants of this meeting outside of the committee to take the floor and present your findings, and take this opportunity to share whatever is relevant to our work at the moment. Thank you. Yes, Ms. Srinivasan, I think you can take the floor now.
Thank you so much, Minister. We really want to thank you for this opportunity to present the findings of the report that we released earlier this year on sexual violence in South Asia, which looks at legal and other barriers to justice for survivors. We have also released a specific country fact sheet for the Maldives, which is available in both English and Devehi. So just wanted to point out that we have a Maldives specific resource available as well. So before jumping in to the issue of protection gaps in the laws on sexual violence, I just wanted to quickly take you through the methodology that we employed for the report. So we focused on 6 South Asian countries: Bangladesh, Bhutan, India, Maldives, Nepal, and Sri Lanka, because we wanted to do a sort of comparative analysis of the laws in these countries, as well as the barriers to accessing justice within the system. So our research was based on both primary and secondary data. So we had interviews with 28 survivors and 20 stakeholders across the 6 countries. Though unfortunately for the Maldives, we weren't able to directly speak with survivors because of difficulties in access, and also because our research took place during the pandemic last year. And it was also based on secondary data, which is the analysis of the laws themselves, human rights reports, reports of CSOs and relevant government authorities, and of course of international human rights organizations as well. So I think I'll just start off with the gaps in the laws because that's what we're most concerned with today, and then we can go back to the other issues, including reporting, etc., at the end if there's time. So just to begin with, across the 6 countries, we identify these 3 major gaps. The first one is in terms of limited definitions of rape, particularly when there's all forms of sexual penetration are not included in the definition of rape. Now, this is not a problem in the Maldives, but I just wanted to point out that some other countries like Bangladesh and Nepal don't have as comprehensive a definition. But of course, now with the 2014 Sexual Offences Act in the Maldives and the 2009 the Act on Child Sexual Abuse, that part is quite well covered under the law. The other 2 gaps are really more relevant for the Maldives. The first is the failure to recognize marital rape in all circumstances. Actually, Nepal and Bhutan are the only 2 out of the 6 South Asian countries that we studied which have criminalized marital rape in all circumstances, and they're sort of showing the way for the rest of the region to follow that example also. Another thing I wanted to point out specifically to the Maldives is that the Child Sexual Abuse Act actually also has an exception for marital rape. Even though now the law says that the minimum age of marriage is 18, the 2009 Child Sexual Abuse Act has not been amended to ensure harmony with the minimum age of marriage. So that loophole in terms of exception for child marital rape also needs to be closed in the Maldives. Then just moving on, I think just moving on to the specific gaps in the laws in the Maldives. The first one that I really wanted to point out is under Section 52 of the Sexual Offences Act, which states that when 5 types of evidence are available, they are sufficient to prove the case beyond a reasonable doubt. And the provision itself specifies 7 different types of evidences which can be produced, out of which 5 are necessary for a conviction. So some of them are, for example, forensic evidence, statement of the victim, the physical injuries on the body of the victim, etc. So I think there are 3 main issues which I really wanted to put out. The first one is that some of the types of evidence which are included in the section itself are themselves discriminatory, and they're based on negative gender stereotypes. For example, one of the types of evidence which are allowed to be introduced is the statement of a third party as narrated to them by the victim within a short period of time from the occurrence of the incidents, and when there is no probabilities of the victim fabricating the story. Now, I think there are 2 problems with this subclause. Firstly, the requirement that the statement has to be narrated by the victim within a short period of time from the occurrence of the incident. Now, we know there are so many reasons why victims, do not come forward or do not even share their stories of sexual violence with other people, for fear of shame, stigma, there's a fear of threats and retaliation from the perpetrator, and many other reasons. So this is sort of like a limitation in the law which prevents access to justice for victims. And the second part, which also says that there should be no probabilities of the victim having fabricated the stories. Here, the law itself is starting from the assumption that there are many false cases which are being filed by victims, which I really think that we need to try and combat. Another type of evidence which can be introduced under Section 52 is evidence of physical injuries on the body of the victim. Again, I just wanted to point out that not in all cases of rape, there won't be physical injuries on the body of the victim, because in many cases, like all victims react differently to rape. And in many cases, especially if the perpetrator has threatened the victim or threatened the life of her family, then she may not be actively physically resisting to the act of rape, even though it is not consensual in nature. So this actually this actually says that there should be no requirement for a specific piece of evidence to be available. example, physical injuries, and it says that medical evidence. And that brings me to my second point. I feel that Section 52 of the Sexual Offences Act is not in accordance with international human rights standards. The CEDAW committee, when it reviewed Maldives in 2015, had expressed concern about the stringent evidentiary requirements which are there under the law for proving rape. And coming back again to the model law, rape law, which was issued by the Special Rapporteur this year, that also says that there should be no requirement in the law for the testimony of the victim to be otherwise corroborated in order to be considered as credible, reliable, and sufficient for a basis of conviction. In accordance with these international human rights standards, actually in the other South Asian countries that we studied, the courts have held that the sole testimony of the victim, if it is found to be reliable and credible, can be sufficient as a basis for conviction. So now the courts already look into this to see whether the testimony of the victim is reliable or credible. But having a requirement in the law itself to have 5 different types of evidence is a very heavy burden. It's the highest burden that we found in all the 6 South Asian countries that we studied. And actually, I just wanted to quote one line from the Supreme Court of India case, in the case of State of Punjab versus Gurmeet Singh, where they talk about this question of evidence and corroboration. So they say that seeking corroboration of the victim's statement before relying on the same, as a rule in such cases, amounts to adding insult to injury. Why should the evidence of a girl or a woman who complains of rape or sexual assault be viewed with doubt, disbelief, or suspicion? So that's the first major gap in terms of the evidence requirements. And actually, there's a lower evidence requirement for children because there are 9 types of evidence which can be introduced. But the Supreme Court of Maldives has very liberally interpreted the provision under the Child Sexual Abuse Act to say that the statement of the child themselves is given greater weight. And we really need that same kind of either interpretation of the law or changing the law itself made for adult victims as well. Now, the other section that I really wanted to point out in the Sexual Offences Act is Section 53, particularly subclauses B, C, D, and E. Now, subclauses C, D, and E are already proposed to be deleted under the Sexual Offences Amendment Bill, which is currently pending before you. But I wanted to take this opportunity to, sort of add our voice on why we think subsections C, D, and E should be deleted, and also to make the case for deletion of subsection B as well, which is currently not included in the bill. Now, Section 53 says that the occurrence of certain circumstances can be used to deny accusations of sexual violence, including under B, the long delay between the occurrence of the incident and the date of reporting, if the incident was not narrated to other persons in the meantime. Now, this is similar to sort of that requirement I was already talking about under Section 52. And again, going back to the model law that was issued by the Special Rapporteur, it specifically says that there should be no adverse inference in the law for delays in reporting, because we know that there are so many reasons which deter survivors from coming forward. And particularly, I wanted to point out also to the findings of the Maldives Demographic and Health Survey. It actually found that 36% of survivors didn't tell anybody about the incident or did not seek any help for the incident. And 42% of survivors didn't seek any help at all. So now when we know that there's such a large proportion of survivors of sexual violence who are not narrating the incident to anybody or seeking help, obviously for the various reasons that I've already pointed out, having a specific adverse inference in the law itself for delay in reporting really affects the chances of survivors to obtain justice for sexual violence. So we would recommend also that Section 53B is deleted from the law. And moving on to subsection C, D, and E. Now, subsection C supplied by the victim, facts relating to the dignity and discipline of the victim. And I'll just move to subsection E because it's slightly similar. Again, it says the court opining that the offense was improbable to have taken place, having regard to the relationship between the parties and the transactions between them prior to the offense. Now, reading both these subsections together, it brings in the possibility that defense lawyers can introduce evidence about the past sexual history and character of the victim within the trial. And again, this goes against international human rights standards. The model rape law says that generally the evidence on past sexual history of the victim should be prohibited because often it's irrelevant in this case. And you're also looking what happens is when such evidence is allowed to be introduced, it gives a way for the defense lawyer to basically attack the character of the victim, and then it's the victim that's being put on trial during the case and not the accused. And this deters many victims from coming forward because they're scared of the trial proceedings themselves. A lot of victims often also say that they're re-traumatized during the whole trial process, and the trial feels like a second rape. And it's actually provisions like this which allow defense lawyers to really attack the character of the victim during the cross-examination that contributes to this re-traumatization of survivors. And it also, helps the judge to maybe make the decision on irrelevant grounds based on past sexual history, as opposed to the specific case of whether the sexual act in question was consented to or not. And therefore we believe that this provision should be deleted. And in fact, in India there was specifically an amendment that was made to the law which says that there can be no evidence on the past sexual history of the victim which is allowed to be introduced during a rape trial. And I also wanted to point out the Pakistan also recently changed their law on this. They also had a provision which, they didn't say dignity and discipline of the victim, but it was quite similar, and it allowed evidence on the immoral character of the victim to be introduced. And this was challenged before the Federal Shariat Court in 2009. And the Federal Shariat Court said that firstly, that this provision is discriminatory on the basis of sex because it purports to impeach the credit of a woman, and also that it negatives the concept of gender equality as enshrined in the Holy Quran. And they had struck down the provision under Pakistani law, after which the government repealed it in 2016. So in Pakistan, no longer can evidence on the immoral character of the victim be introduced in the trial. Then moving on to subsection D, which again is already included in the proposed bill, that the court is of the opinion that the incident is likely to have not taken place, having reviewed both parties' accounts. Again, this is sort of enshrining in the law itself this idea that victims are going to be filing false cases, and the story is likely to be improbable. The Constitution under Article 51H already says that for a criminal offense, the case needs to be proved beyond a reasonable doubt. So the court will have to look at, and obviously we'd love to hear from you and also any questions you might have in terms of the reasons why we think the law should be deleted.
Can I just sorry to interrupt, but I think Hume wants to point out something.
Yeah, Divya, you just dropped out, so if you could just go back a minute.
Yeah, sure.
That will be helpful. Thank you.
Do you want me to go back to section 53D, or was that clear? Okay. Yeah, so section 53E basically says the court can opine that the offense was improbable to have taken place, having regard to the relationship between the parties and the transactions between them prior to the offense. Now, the problem, I think, really the problem with this provision is, again, it's based on negative gender stereotypes, and it allows sort of the introduction into the trial of questions which might be sort of irrelevant to the rape itself. Like, for example, like what was the victim doing, or like, whether she had been friendly with the perpetrator beforehand, or even questions of, what she was wearing, because the transactions between them prior to the offense can be read quite broadly. And it because of these harmful gender stereotypes, and again, the question of past sexual history, which I think comes in here, are reasons that we think subsection E should be deleted. So, Hume, do you want to talk about the section of our report, which is more in terms of the implementation of the law and the barriers to justice within the system.
Thank you, Divya. Yes, I can. If you can
Sure.
just pass on, go to the next slide. Yeah. Maybe I can take this in Divehi, if that's okay with you. Okay. Mihar, mi ganun mi aniyage shikarekawa faratun ganunu ga oy farwa hoduma waragina mi hurastan hurikaman argumenna fahagawani mi dirasain anghenaka viti kuroda discussion libe eba mi fandiaraves eti godgota ganunu mana kuran ehmima argumenge mujtama gonna mi tafat kurun takha stereotyping hama fandiarge faratu mes pennani ehmima e wara nei mi ehmima nei mikhala halategga mikhala kesegga kota da mihaves devana faharan aniyawa gota mi dimarigen tani system ge terenves එහෙනම් නේ මිකහල මස්සල්තන් දෙන් අදි ඒගේ ඉතුරුන් වර දිගුලා දත්ත අල්ගොමෙන්නන් හම නුස්තකුම් වෙසබ ෆෙනේ දිහාහර් වෙජ්ජ මේ කේස් ඔන්නතා එහෙනම්ස් අදිවස් එවස් හබරන් නොවේ එහෙමම මිකහල බොඩ අනියා වා මීහකි මුජ්තමගේ තරගවස් වර බොඩ ටාගට් කරවි ෆාහග කරවි ෆාඩුකි ඒනය අබදවස් නසර් මෙ හින්ගෙනි කන් කුරාමි හයක නසර නොහින්ගේ එමෙම එගොතුන් දිමාව මසල්තවගේ තෙරේගා ඒන කුරි එකමන් අවුන්නස් මේ මසල රිපෝට් කරුමම් වෙස් දෙහිලුම් වේ ඒ අල්ගොමෙන් එන්නෙන් එන්වයරන්මන්ට් මේ කල සීරියස් මසල්ත රිපෝට් කරු කොග්ගෙන් ඒ බලා ගන්නානේ ඒ මාහවලෙන් අල්ගොමෙන් ගෙනේ ඒ සිස්ටම් ගේ තෙරේගා වහක් වෙදක්කනේ එම්ම පුරතම ෆ්‍රන්ට් ලයින් ෆුල්හුන්නා හිසාබුන් ඒ තියබ ෆේල් වේ එහෙනම් මල්ගොමෙන්ගේ නිසාමී ගොතුම් මේ මසල ඔය මිම්බර් හැම වර සාෆ් කොන් හැම වෙගෙන්ද දෙන් මේ අල්ගොමෙන්න වදාදි ෆහුන් දෙතෝ මේ මෙඩිකල් එක්සාමිනේෂන් ගේ මසල මේ අයි ඒ රේප් කිටන් ඇක්සස් නුහුරුම අද ඒක ඉතුරුන් අල්ගොමෙන්න ඉංගේ මිහාරු එබොෙන්ගේ තෝ මේ සිහි ගොතුම් මිකහල අනියාත ලිබේ පරත්තක හස්ස mi ahamiyat ka meddigen e investigation process ka medical practitioners amal kuram vi gotuge guideline eves algomennan inge gotun as medical practitioners mi ahulwari echennu emi hun denje he farwa dinumavves nukule detam mi annani ei medical legal report innaki onnje echen investigation process ke terega ehem vima මිහාරු ෂෙල්ෆෝ මේ ඉස්ලාම් තවගේ තෙරේගා රේප් කිට ලිබුමා අදි ඉන්වෙස්ටිගේෂන් ගා ෆොරෙන්සික් එවිඩන්ස් නෙගුන් එහා බොඩු ඉස්කමෙත් දෙවෆ උති එහෙම මේ අල්ගොමෙන් හැම පහක් කරා කමෙන් ඒ කුරංජේ කමෙන් එන්නමස් මේ ගයිඩ්ලයින් තක කුරමිගන් තක නේගිගෙන් නෙතිගෙන් නුකර වේ කමෙන් වෙස් නූනේ හැම පහක් කුරංජේ එංගේතෝ ඒ අල්ගොමෙන්ගේ administration ga ule war bodati masaltake ei mi health protection agency nu ata ministry of health mi devanje he tamrina mi chive starti before kan argument inge ennames mi training ves ala dihrajan anna doctor waragina doctor naki berun anna parata datta e mi hunna ves ahulari kulanje he dihrajega mi ene ganuni gotun emi honna lazim kura kankama emi hunge zimma mi rayituna khidmat dinumuga ufulum then ehemmima mihuriha kame evvegen as reporting mi kudawani then reporting kudawima kinatto algommenna evves kehe kota kumves nukunatam fennani ekeshegen wa femwara nuni minwara e beligen ene malumenge maaba president taka business etwefuke sexual violence avisnaeru amadun rape convictions ge data ya bala irves nete denna vies samala alwe mi dakkani godet mi hunge waka hasagotegga udapudinge ka ane halat ga mi haru fudewarka gina masekatake kurevigen mi dehas baragi ganun undeta mi eyan address kureveba ehen namma ves godet mi hunge halat ga hama igut ko ves ane mi nizamu masekate nukureye nizame nefade algumenna mi saaf ko ingen cheki emima mi hurasta wara muhimmu ne tie committee balwadeva adi miharu islah kuran ushala fo e kankamge ituru argumen vesama eba hushalan ne bay kantata ege terega pansa timana madda hasagotegga ingeto pansa timana madda ge ebu hure wara boda aniyage shikareyakwa miha ya deterega mi dogutumatu ne kuru mi ena deni ena kura ena rakka wahake ki dogukama belevene gogota mi ibaratan ebahuri emima ehenen aslu ne dawlatun ena ayak ehabudu aniya vena muli umuran eti ege takuli fufulen jehe fada aniyage wahaka mi dakkani eya divehi dawlatun rayitun nan evves mi insafe adi emi hunna denjehe ehitarikama mikan hutuma ehemmihaka vianu denuma kurenjehe kantattakavves etendu nukurevi kan argumennan ingeni mi halat oy gotun den ene ijtimai hidmat ge nizam kives argumenge terega hama anikale sama wara ene dakko oy kame ei abadu gender ministry ge commerce kame nuege mi uleni FCSC ei atulterega hidmat den hunna kanta etantanuga mi hunnati enharwa mi ekasigenwa femberge mi hidmat dene mi hun muwazzifun netives huregen case takan etendunu kurave halat ke waha kalgumenna habartukum fene emima mi fembaran aslu halat dani e nizama ekasigenwa mi wasilattaka e nizam hinguma benuma mihunna mihuriha kantata argumen ge terega gaim kurefa adives neti ingeta miharu ne women's affairs mi department kum presigen gender ministry divarajye ge hunata miharu haddiha ga harta kun suren eba huri ingeta mi thang namuga ehnama e tanun denche hidmata e tanun devenje rakkaterikama e tanun dawlatu mufulanje zimmatan hama onnani nuefa alon dannawa nehema mi majliha alon ane mi tibefun anti committee an alon hama warabodan ane mi agme jamia faratun warabodan eden mi ijtimai hidmat ane for koddinuge nizam hardana kureveni emi hunna denuma wasilata libgenne emi hunnaka eggut kavves nengeto ane aliftalge kommes jamaatekkun de hine hiyega de rajye ane mi hunge rakkater kama salama hodumuge nizam fasa hoda ehennen nun ekan onna mani kiye ekam ko ehen oti ekam abades kommes ta ku UN agency yakun funding hodagen program hingam mijeheni building ebahuri muwazzafun koleme sebatibe ekam ko program hingen jeheni mi hama jamia hi mi ekam dawlat ke muassasa emema mihalatu eba jeheye war boda badal kuran den mi ege terega mi ekishigen wa femara mi hidmat de faratan e fulhun kam gavias ene mi ministry ge social workers kam gavias adi mi court toge pandiarum vias ebe jehe mi train ma mikam kama adi mi insaniyat kama insanunna de hidmate gotuga ekan eba
Thank you so much. So I think really
so
the
Divya,
left about the key recommendations that we have in our report. So we've divided the recommendations into 5 main heads. The first one is to address protection gaps in the law. And specifically for the Maldives, there are to remove the discriminatory or burdensome evidence requirements in the law, including through amending sections 52 and 53 of the Sexual Offences Act. The second is to explicitly criminalize marital rape in all circumstances, including marital rape of children. And the third is to expedite the proposed amendments to the Sexual Offences Act, which are currently pending. The second head of recommendations is really on improving police responses to cases of sexual violence. And for that, there are 3 main ones. Firstly, to improve accountability of police officers who, fail to register cases which are brought to them by the victims or to fail to effectively investigate cases of sexual violence. The second is to increase training and capacity building, particularly gender sensitization of police officers. So they are also made aware of the issues that rape victims face in filing cases and going through the system, and ensure that they're more sensitive in their responses to rape victims. And the third, I think, is a very important one, which we found across the region, is really there's a high prevalence of threats and fear of retaliation from the perpetrator, including threats of violence and death. So it is to improve the effective implementation of existing laws and policies on victim and witness protection. The third head of recommendations is on ensuring survivor-friendly medical examinations in rape cases. So one is to train medical professionals on the appropriate protocols and to impart training and skills to practitioners, because often there aren't enough practitioners who know how to conduct the specific forensic examinations which are required to examine rape victims. The fourth head is to improve prosecution and trial of sexual offences, which is firstly prioritize investigation and prosecution of sexual violence offences, ensure that survivors are sufficiently supported throughout the legal process, that they know, given updates on what is happening in their case, they provided support while going to court or even while reporting to the police, and to proactively address delays in the process. And this is also a very big problem in the Maldives, because we weren't able to find exact data on this, but based on our stakeholder interviews, we found that sometimes cases of sexual violence can be pending for over 10 years. And often survivors, stop attending trials in between just because the case is taking so long. And sort of this is the re-traumatization they have to live for so many years after the offenses occurred. And fifthly is to have holistic interventions to improve access to justice for survivors. And this point really looks at the fact that, of course, improving access to justice is incredibly important, but it's not the only factor that we need to look at to ensure that all survivors' needs are met. Firstly and most importantly, we need increased funding and allocation of resources towards sexual violence prevention and response programs. There's a need for improved data collection. Actually, even while doing the research for this report, often we found it very difficult to find publicly available data, for example, on the number of rape cases reported to the police every year, or the number of the cases in which conviction has been obtained. So there's a need to improve transparency as well as data collection. To have a multi-sectoral response to provide holistic support services to survivors, including particularly psychosocial services and counseling, which again stakeholders have pointed out is often a gap that survivors are not able to access mental health services. To implement perpetrator rehabilitation programs, so that again the focus is not just on the victim, but also on the perpetrator to try and ensure that they don't reoffend. And finally, to empower the public, particularly women and girls, to understand their legal rights, to improve their awareness, and to ensure that they even know who to approach or what to do if such an incident happens to them in the future. In many cases, for example, what victims would often do is take a bath immediately after the rape incident, without knowing that if they do this and then they go to report rape, then the evidence of rape cannot be found in the medical examination. So this problem needs to be addressed in various different angles, going back to the law provision, we need to recognize these difficulties of the victims and ensure that the law is not exacerbating it. But on the same time, we also need to educate the public themselves to be more aware of their rights and also the responses that they need to have in these issues. So yeah, this is sort of the end of our presentation. Thank you so much for your time, and we'd love to hear any questions or feedback or anything that you might want us to explain further.
Thank you, Divya. Would you like to add anything?
Argument aslu mi feshumuga equality nawa divyaya introduce konnu levetive ane mi har feshumat da alena pulsata devashe warboda maaf karawati mi divya aki equality naw ei bainalagwa mi jamaate mi ane deflunge magandu mi focus ki anghen kudinna kura ania jinsi ania di tafat kurun tawge sabun libe ania dirasa ko mi ekan kambadu kurma e gaum tawga wakalat kurun den mi dirasa yaki divya vidalhen mi hagaumegge mi sarhadduge hagaume ge halat denegatuma kuri masekkate den media haru mi maseke kurvigen diyei එහෙනම් මේ හර report ඒප්‍රිල් මහ මේ ශායු කුරමුනි දැන් දිව්‍යාකි report ගේ එන් උත එවාකේ සල්ගන් හම් දන්නවලම් වෙනු දිව්‍යාකි මේ human rights lawyer එබෙස්ලා මේ ජම්මියා ගමසක කුරවණි research එක හැසියතුන් අඩි මිකලා බොඩෙති multi මේ country studies ga එබෙස්ලා බාර වඩා ගන්නවා research එක හැසියතුන් then argument jamia age eduma mi tibeflun mi wagut devima argument wala boda shukranna argument mi hama abdes masake kurang mi ijtimai kankamuga diamundun anhenun na dimawa bodet masaltafga argument ekankama adufla ekankama mi hew badalegena mataka argument ge jamia masake kuramundani eniyatuga argument upedigen aives ehmema anhenuna viti kura tafat kuruntaka anhenuna viti libe aniyataka deve aniyataka anhenuna viti kurave eki tafat kuruntage sabun emihunge halatu ehmihunna tafat nikameti bumge masale ki ane duniyega ek kankultoga dimave pawa masale dive rajya gese kan oti hen emima algomen ekama wakalat kurang mi masake kurani den evve swale otiya hama tibefluna mi divyaya asong otiya ingata kuriya genda warboda shukriya adi argument ne mi mugadevge arihun request kollam argument ne babbenwe kuda video call evs tibefuna hissa kollam mi ya ne mi dirasa ga machabina ko shukriya
ಕುಶುಗೆ ಶಿಕಾರ್ಯವ್ವ ಮೀಹ ದೆವಣ ಪಹರ ಶಿಕಾರ್ಯಕಂ ಹೆದುಮಾ ಮಿಂತಿಗೆ ಸ್ಟೆರಿಯೋಟೈಪ್ ಕುರು ಜಿನ್ಸಿ ಕುಶುಗೆ ಶಿಕಾರ್ಯವ್ವ ಮೀಹ ದೆವಣ ಪಹರ ಶಿಕಾರ್ಯಕಂ ಹೆದುಮಾ ಮಿಂತಿಗೆ ಸ್ಟೆರಿಯೋಟೈಪ್ ಜಿನ್ಸಿ ಕುಶುಗೆ ಕಾನೂನು ಕುಶುಗೆ ಶಿಕಾರ್ಯವ್ವ ಫರ ಇತರ ಶಿಕಾರ್ಯಕಂ ಹೆದುಮಶಾ ಮಿಂತಿಗೆ ಸ್ಟೆರಿಯೋಟೈಪ್ ಕುರ್ಮ ಜಾಗದೆ ಮಿಹಾರು ಕಾನೂನು ಒಗ್ಗುತ್ತುಂ ಕುಶುಗೆ ಶಿಕಾರ್ಯವ ಮಿಹಾಗೆ ಮಾಜಿಗೆ ಜಿನ್ಸಿ ಗುಳುಮಶಾ ಏನಾಗೆ ನಫ್ಸುಗೆ ಅಬುರುವೆರಿಕಮ ಅಹ್ಲಾಗ ರಿಯಾಯಕ್ಕೋ ಏನ ಹದನಿ ದುಗುಕಮ ಕೋಟು ನಿಮ್ಮುಮ್ಗೆ ಜಾಗ ಫಹಿವೆಫಾವೆ ಕುಶುಗೆ ಶಿಕಾರ್ಯವ ಮೀಗೆ ಇತುರುಂ ಮಾಜಿಗೆ ನುಹಿಂಗಾಕಮ ಕೋಟ ಶಕ್ಕು ಕುರೆವಿ ಅದಿ ಗಬೂಲ್ ಕುರೆವಿ ಏಗೆ ಮಚ್ಚ ಕೋಟುಗೆ ನಿಮ್ಮುಂ ದಿನಾ ಕುರುಮಗೆ ಫುರ್ಸತ್ ಹದನಿ ದುಗುಕಮ ಫಹಿವೆ ಕೋಟು ನಿಮ್ಮುಮ್ಗೆ ಜಾಗ ಫಹಿವೆಫಾವೆ ಜಿನ್ಸಿ ಅನಿಯಾಗೆ ಮಸಲ್ತ ಕೋಟು ಬೇರು ಕುರುಮ ಬೇನು ಕುರೆವಿಗೆ ಮಾನೆ ಉಜ್ಜತೆನ್ನು ಅದಿ ಗಬೂಲ್ ಕುರೆವಿ ನಿಕಂಕಮಗೆ ಸಬಬು ಇನ್ಸಾಫ್ ಹೋದುಮ ಉರಸೆಳಿ ಜಿನ್ಸಿ ಅನಿಯಾಗೆ ಶಿಕಾರ್ಯವ ಫರಾಯ್ ಇತುರ ಶಿಕಾರ್ಯಕಂ ಹೆದೆ ಜಿನ್ಸಿ ಅನಿಯ ಸಾಬಿತ್ ಕುರುಮ ರಿಯಾಯತ್ ಕುರಂಜೆನಿಗೆ ಅನಿಯಾಗೆ ಕುಶಾಬೆಹೆ ಹೆಕ್ಕ ಗರೀನಾ ಅದಿ ಕೋಟುಗೆ ಸಮಾಲುಕಂ ಎದಿಮಾಯ ಬದಲ್ ಕುರುಮ ಕಾನೂನು ಬದಲ್ ಕುರಂಜೆ ಅನಿಯಾಗೆ ಶಿಕಾರ್ಯವ ಫರಾತಿಗೆ ಬಯಾನಕಿ ಮಸ್ಸಲಾಗೆ ಅಸಾಸಿ ಹೇಕಿ ಜಿನ್ಸಿ ಅನಿಯಾಗೆ ಶಿಕಾರ್ಯವ ನಿಹಾ ಬದನಾಮ್ ಕುರುಮ್ಗೆ ಬದಲ್ಗ ಏನಾಗೆ ವಾಹಕ ಗಬೂಲ್ ಕುರಂಜೆ ಅನಿಯಾಗೆ ಶಿಕಾರ್ಯವ ಫರಾತುಗೆ ಬಯಾನಕಿ ಮಸ್ಸಲಾಗೆ ಅಸಾಸಿ ಹೇಕಿ ಜಿನ್ಸಿ ಅನಿಯಾಗೆ ಶಿಕಾರ್ಯವ ಮಿಹಾ ಬದನಾಮ್ ಕುರುಮ್ಗೆ ಬದಲ್ಗ ಏನಾಗೆ ವಾಹಕ ಗಬೂಲ್ ಕುರಂಜೆ ಕೊಮ್ಮೆ ಹಾಲತಿಗಾವೆಸ್ ರೇಪ್ ಅಕಿ ರೇಪ್ ನಮವೆಸ್ ದಿವೇ ರಾಜ್ಯಗ ಖಾವನಿಗೆ ತೆರೆಗ ಕುರಾ ಜಿನ್ಸಿ ಅನಿಯ ಮತ್ತು ಮ್ಯಾರಿಟಲ್ ರೇಪ್ ಹುರಿಹಾ ಹಾಲತೆಗ ಖುಷ ಕಣ್ಣುವೆ ಕಾನೂನು ಬಯಾಂಕುರಾಗುತ್ಗ ಖಾವನಿಗೆ ತೆರೆಗ ರೇಪ್ ಕಮ ಬೆಲೆವೇನೆ ಹತ್ತರು ಹಾಲತೆ ದಿವೇ ರಾಜ್ಯಗ ಖಾವನಿ ರೂಳು ಮುಗೆ ಮರಹಲಾಗವ ಹಾಲತ್ಗ ಖಾವನಿಗೆ ತೆರೆ ಕೊಮ್ಮೆಸ್ ಬರಿವುಮ ಖುಷಾಳ ಫಾವ ಹಾಲತ್ಗ ಕಾನೂನು ಬಯಾಂಕುರಾಗುತ್ಗ ಫಿರ್ಮಿಹಾಯ ಬಿನಿಹುರೆ ಗುರಕ್ಕಾತರಿ ಜಿನ್ಸಿ ಬಯ್ಯೆ ಅಂಬಿಮಿ ಹಾಲತಿಗೆ ಹಾಲತ್ಗ ದೆಮಫೆರಿಂಗೆ ದೆಮೆದ್ಗಾವ ಇಬ್ಬಸ್ಕುನಗೆ ದಶಂ ಮಕಿಂಗ್ ದಿರಿಯುಳು ಮುಂದ ಹಾಲತ್ ಬರಿವುಮ ದೆಕುನೇಶಿಯಾಗೆ ಹಿಂಗಂತಕ ಬಲಾಯ ನೆಪಾಲ ಭೂಟಾನ್ಗ ಹ್ಯಾವೆನಿಗೆ ತೆರೆಗ ಹುರಿಹಾ ಹಾಲತಿಗ್ಗಾವನಿ ದೆಮಫೆರಿಂಗೆ ದೆಮೆದ್ಗಾವ ರಾಜ್ಯಗಾವೆಸ್ ಮಕಿಂಗ್ ಬದಲು ಗೆನ್ನಜೆ ದೆಕುನೇಶಿಯಾಗೆ ಹಿಂಗಂತಕ ಬಲಾಯ ನೆಪಾಲ ಭೂಟಾನ್ಗ ಹ್ಯಾವೆನಿಗೆ ತೆರೆಗ ಕುರಾ ರೇಪ್ ಹುರಿಹಾ ಹಾಲತಿಗ್ಗಾವನಿ ಕುಶಕಂ ಹೆದಿಫಾ ರಾಜ್ಯಗಾವೆ ನಿ ಬದಲು ಗೆನ್ನಜೆ ಜಿನ್ಸಿ ಕುಶಕ ಕಾನೂನು ಗುಣಾಗುತ್ಗ ಗದಕಮ್ಮು ಜಿನ್ಸಿ ಅನಿಯ ಮತ್ತು ರೇಪ್ ಸಾಬಿತ್ ಕುರ ಫಸ್ ವಕ್ತರೆಗೆ ಹೆಕ್ಕಿ ಕುಶಾನಂಜೆ ಮೀ ಸಿರಿಯಾತ್ಗ ಹಿಂಗ ನಿಫದ ಜರೀಮಾಯ ಸಾಬಿತ್ ಕುರ್ಮಮುವೆ ಬೋಡು ಹುರೆ ದೆಕುನೇಶಿಯಾಗೆ ಹೆಂಗಂತಕ ಬಲಾಯಿರು ರಾಜ್ಯಕಿ ಜಿನ್ಸಿ ಕುಶುಗೆ ಕಾನೂನುಗ ಅನಿಯಾಲಿ ಬುಣ ಫರಾತಂಗ ಹೆಕೀಗೆ ಬುರ ಎಮ್ಮೆ ಬೊಡ ಫುಲಂಜೆಹಿಗ ನಿಫದ ಜರೀಮಾಯ ನಾಗತ್ ಕುರ್ಮ ಅದಲ್ವಂಜೆ ಬೋಡು ಹುರೆ ದೆಕುನೇಶಿಯಾಗೆ ಹೆಂಗಂತಕ ಬಲಾಯಿರು ರಾಜ್ಯಕಿ ಜಿನ್ಸಿ ಕುಶುಗೆ ಕಾನೂನುಗ ಅನಿಯಾಲಿ ಬುಣ ಫರಾತಂಗ ಹೆಕೀಗೆ ಬುರ ಎಮ್ಮೆ ಬೊಡ ಫುಲಂಜೆಹಿಗ ನಿಕಂ ಅದಲ್ವಂಜೆ
Follow Alana. Sual et nota commentem speflako mi fursaske beno kurama. Ishara kolda varana not kola. साफ ये तो आलोन में मिहारू कानून मी हुशाला फैंग इस्लाह तक बाला लायरो I don't English and that would be the right way to do that. Okay, sorry, Divya, I will continue in English. Thank you so much for the brief summary of the research and the clarity with which you've presented your case, and I think it's very clear to all members hear what you're proposing and why you're proposing it, and it's well justified, and we, as a committee, accept the proposals that you've put forth, and we believe that that's the way forward as well. And I just also wanted to point out, that from the amendments that you've proposed as recommendations in this report, Section 53E is actually already proposed to be removed. So, Section 53 B, D, and E is already proposed to be removed, and the only thing that we need to address right now is Section 53. Section 53D. B is what we need to attend to right now, because B is not proposed for amendment, and I think the committee will consider Yes. I just wanted to point out that in the presentation, I think we've missed one point, that is the fact that Section 53E is already proposed for removal. So I think that's taken care of. And like Honorable MP here just pointed out, with the current amendments do not take into account Section 52 and the heavy evidence, the burden of evidence. And so I think we will consider that as well, and revisit Section 52 and see what we can do there. With the other recommendations that you have proposed, under the recommendations under ensuring survivor-friendly medical examinations in cases of rape, I think the law, as far as the law goes, I know that there's the training of the personnel, training of medical officers and other relevant persons that we need to get into, but as far as the law is concerned, I think what we have in proposal right now is exactly what you're proposing, a survivor-friendly medical examination, which did not exist before. And I think we have, the good thing is we have consensus from all stakeholders and meetings with all stakeholders on moving ahead with this. And so this amendment will most likely be taken in when we go ahead, so which is a very positive outcome of what the work that we're doing right now. Similarly, the removal of sections D, E, and under 52, under section 52, D and E is also supposed to be removed, and I think we have consensus on that as well. So what we need to discuss right now is Article 52 and Article 53B revisited again. And I guess that should, in terms of the law, take care of a lot of the recommendations that you've put forward, and I think that should put us in par with the standards that is expected of such a law. In terms of the protection of children in marriage from marital rape, I think we will revisit I will have a look at the 2019, the recent amendment to the Child Rights Protection, the new Child Rights Protection Act, and to begin with, it prohibits marriage, underage marriages to children. So I guess in a way that we've addressed that in a way, but then we have to take into account that there are already children who are married between the ages of 16 and 18. I think we still have some, and so what we can do for them is, in terms of law, what we can do for them is what we need to revisit. So we will take a look at that as well. That should take care of the law and what we can do from here at committee level immediately, in fact. In terms of improving, what did I note. Social protection services, the resources, what we have been continuously doing over here at the committee in the past 2 years is reviewing the budget of the women's missionary. And last year, I think it's the first time in history where the ministry's come and said we have enough budget, and which is true. It is the biggest budget that they've received so far. So what we can do as committee here is, I think, continue to dissect the budget for protection for women, and then continue to see that the social protection services has the resources it requires, and budget analysis is, I guess, something we can continue to do. But what we also need to see continually, like you point out, is how the police response, implementation of the social protection services, prosecution rates, how trials are conducted, and basically how the system responds to what is in the law is what we need to be doing continually, and I guess that's the monitoring role of the committee. And we have the mandate to do it via the other institutions such as the Family Protection Authority, the Human Rights Commission, other monitoring bodies, and then and also to review on a case-by-case basis, which we have done over the past 2 years or so. So I guess that is the commitment you have from us, and it's been very easy because it's been very timely, that this meeting and our review of the law and the work that is ongoing, although it's one of the most difficult laws we have had to maneuver, because understanding and getting people to understand how stereotypical views of women and how stereotypical understanding and cultural associations with women, how we need to deconstruct it to make changes in the law. That has been tough, and so we will see. Hopefully, we will in the coming days as we go on to address finish the review of the law. We will revisit Section 52 and Section 53B. Anything to add to Colin? Yeah, please.
Thank you so much. Divya, I'll go ahead and Divya again. Alan adi me Supreme Court ke judgment detto kuda pudinge hekige burada e lawyer ve sannanje kamek kannenge detto ganunun ane rakateri kange bali benche kannege. Yeah. Ganun ge 52 ge wahan pe tati dali. हम एगुतंग इन द या मी कुडकुदिन एने देहास 12 के गानुन एने एजेंसी गोना कुर्म के गानुन एने has yeah 2000 e ganun ge imada veseba me danna ke ki Supreme Court ke president is there ehen nama ves ganunu neddetto e rakkaterikamen adives. Yeah. And there's a chance it will again go members whether yeah. A president riaya kuriya detto innani. Hendune ganuna kullaji mennu kureta. Adives. E faragu detto e gap. Then alani venika me itpa hidmat ge nizam ge me fund ge kankamuga asu miharu e daira dipe inna fund war bodu e fainani inspire hurachves ekkola fainati detto no okay 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 then I don't understand where absorption capacity with issues hunnane kan he names ane mi hilehiya barosa nuwe dive dawlatun ekan kurumaki algomen kurenje kameke algomen ge darinna vaccine denje henive UNICEF kun nun detto mi har mi har war gina dosen den oiggoen ekan emim ekal asasi hidmat dawlat ge budgetum ene fuddenje hene wahaka algomen hama pahakola den ene mi algomen war bodan edenge to mi miharo mi gender based violence abe health response kommes gotakun eya bar devene gotetti beflum hadda deviya ei guideline evima eyaka tamfize bes nukure eyaka beleni kiyennun follow kurani kiyennun hennamas ei wara muhim kame miga emem e gap inha hindaku algomen mi dambe numatana diumaki latkama kawane embe ma faruage baga ei war bodan himanalan chekama hama faakule bende to faagwe fa den all right okay okay yeah final point kan alon hama ane mi gershanya hutumge ganun mesinde dutto mi ane ania mi ania kura faratta ge rehabilitation na samalubun den ekan algomen mi har ane divyage mi presentation guys ekan pahako fendi hen namas algomen nan ei ane gershanya hutum ganun umbes adives tamfiz nukuraviye kame vima eya bara bodan eba samalwan jehe kan nari itra thank you
ewa kabunela fasu mi ane di demme budget dewa ka mane danna sedatto the other issue is hama ekala skills neto professional se daira ge neto misala ka social work misal counseling mi psychologist mi rajye gawara madu hunaru takedet ane e hama miya menani gulifa e masu adequate service takenuli beneta mi kinuli me skills ta produce kuran ei sarukaruge mi amada kawandi hekane the other thing is hama institution takuge collaboration netuma hedi yenna challenges ehme nizam se buhuri eka mi ekko gulige masakek kura e ruhu neti manna challenges yeah
Divya, thank you very much. We have been just carrying on in Divehi. Thank you for your patience and also for your time for sharing the information with us today. So I will pass on to the chair. Thank you.
I just want to echo Marie and Hume's gratitude and thank you for joining us and sharing your thoughts and the findings of the research with us. This has been very helpful. Thank you to Uttama also for this collaboration with you and sitting with us today for this very useful and insightful meeting. We always enjoy having these kinds of opportunities with CSs and especially Uttama. Thank you so much, Divya. Thank you. Members don't have
Thank you very much.
Comments. We will conclude today's committee meeting, and as we move on with the bill, we will definitely consider the proposals put forward. Thank you so much.
Thank you very much.
This has been very useful.